The broadcast is now starting. All attendees are in listen-only mode.
Good morning and welcome to the webinar. This is Roger Royse. I'm the founder of the Royse Law Firm. It's a business, corporate, and tax law firm with offices in Northern and Southern California. Today I'm here in Palo Alto with Lisa Chapman, who is a lawyer here at the Royse Law Firm who specializes in employment and litigation and is going to give us a presentation on document retention policies. Before we start, I just want to remind the listeners that you'll see on your screen a text box. If you have questions, go ahead and type your questions into the text box and we'll gather them and respond to those at the end. I'd also like to let you know that this webinar is being recorded and you will find the slides will be posted on SlideShare as well as on our resource site, royseuniversity.com. And you'll find a recording on YouTube, on the Royse Law YouTube site, and it will soon be available for download as a podcast in the iTunes Store. A couple of quick announcements before we get started. I want to announce that we've got another webinar coming up on May 1 on trade secret protection. So if you haven't gotten the announcement for that one yet, please go to Royse University where you can find the login information. We have a conference that we are sponsoring on May 12 on behalf of Silicon Valley AgTech. The conference is on AgTech, that's agricultural technology companies. It'll be at the Oshman JCC in Palo Alto. It's a day-long conference coming up on May 12. So in this age of information overload, companies must make smart decisions about which documents to retain and when and how to retain them. So allow me to introduce Lisa Chapman of the Royse Law Firm, who's going to provide an overview of the legal and practical considerations that should inform your documentation policy, including an emphasis on ensuring that your company is compliant with tax and other relevant laws, as well as practical solutions for handling information overload. So Lisa, go right ahead.
Thank you, Roger, for the introduction, and welcome everyone to this webinar. The purpose of this webinar is to hopefully encourage everyone to take a step back and consider how they are managing, processing, using, and storing the information that is passing in front of their eyes at lightning speed each and every day and during the night while you're asleep. As we all know, there's been a lot of significant changes over the past 25 years with respect to the issue of how do we save, store, use information. As Roger just pointed out, it truly is an information overload situation, which of course comes into play not just in how we decide to store or save our information, but how we interact with our information, how we interact with social media, etc. And I think it's probably time for all of us to take a step back and make sure we're making conscious decisions about which information to store and safekeep for future needs, and which information to simply jettison and let go of and sort of lighten our load, if you will. I would have to suggest that almost everyone at this point relies on what is known as a quote-unquote paperless office to some extent. There is a lot of overlap. Most companies have some types of information which they maintain in a paper format, and yet there's lots of information which they maintain in simply a digital format. I'm going to focus on the paper aspect, in other words, the paper type documents which your company and or you as an individual may be saving. This issue of what to save or what not to save speaks to the concept of efficiency and ease of use. In other words, what's the most efficient way to maintain your information and how can you get at it as quickly as possible without being flooded by what I call the Armageddon effect. In other words, the crash down of just too much information such that you can't find the information you need when you need it right away. As I suggested, this is in large part a result of the impact of social media. There are just so many different ways that we are all being communicated with, and that means that we are all receiving much more information. Information is being disseminated on a widespread basis. So we have to make smarter choices, as Roger said, now, because we have a lot more information that we have access to, a lot of which is just not necessary for our businesses. One of the other issues to think about is the environmental impact of saving paper. Yesterday was Earth Day, and I'm sure everyone knows about that and perhaps had an opportunity to consider the environmental impact of our behavior. Saving paper does, or even actually printing documents on paper and then saving them later, does have an environmental impact, and that's something that all of us probably need to give some consideration to, and that could inform some of these decisions as well. However, as we go down this path and we discuss these issues, my comment to everyone is not so fast. And when I say that, I'm referring to the fact that you can decide to go paperless, but you may be violating laws and regulations if you go down that path. So as you make these decisions, make informed decisions about what the laws require you to do and or not do, and make decisions not just based on convenience, but also based on protecting your legal rights going forward. So the first issue to consider is what is the document retention plan, and a related issue, what goes into that plan? As you consider that big question, there are two sub-questions which you need to ask yourself. Number one, should I retain company documents? And if I should retain them, in what form and for how long should I retain company documents? Those are the two key questions which we're going to focus on. Again, one, should you retain certain documents, and in what form and for how long? The first question, or actually both of these questions, are informed by a variety of factors. One factor is the issue of the legal obligations that a company and or an individual may have to preserve paper copies of documents. And this is governed by various federal and state statutes and administrative rulings. Another factor which should inform these decisions are industry and cultural standards. Some industries rely more on paper documents than other industries. The legal industry is one such industry, and the real estate industry is another. So you have to think a lot about what is the norm in your particular industry and what is considered appropriate. I would venture to speculate that the software industry is not too big on saving paper documents, and that can be a factor that you should think about. And when I reference the term cultural standards, keep in mind that there are a lot of traditions from different cultures and different countries, and these laws and regulations which govern saving paper documents vary country by country, not to mention state by state, of course, but country by country. So if you're, for instance, involved in a cross-border transaction, one of the things you might want to inquire about is, if I get into a dispute in, say, for instance, China, what types of documents am I going to need to have to provide to my attorney to defend me or prosecute a claim? Another issue which should inform your decision is the potential risk of litigation and the legal compliance requirements concerning litigation. I will go into this in a little bit more detail later, but this is always something that you have to think about, and it should be a sort of a checklist question every time you put together a document retention plan or decide to destroy certain documents. And finally, this decision is informed by, in large part, everyone's comfort zone. And that is to say, the extent to which a company is comfortable relying on digital resources to preserve its documents or to destroy documents. Now, with respect to federal and state laws and regulations which govern this issue, taxing authorities impose quite specific legal obligations on companies and individuals with respect to this issue of what you have to save, how long you have to save it. Business income tax returns. Companies are required to save all supporting documents which were relied upon or inform the findings or input, rather, in the business tax returns. So, for instance, if you're going to assert that you're depreciating an asset, then the company needs to save all documents will support that contention. Full corroboration will be required for an audit. Roger, do you have anything to add?
Yeah, so as a tax lawyer, let me just say it a different way. The way I look at it is that the IRS is going to require you as a business owner to keep adequate books and records to support every item on your tax return, and that they be available when needed in a tax audit whenever that tax audit arises, for as long as the statute of limitations arises. So that's sort of the basic rule. And when we think about document retention for tax purposes, we always have to think about statutes of limitations.
Thanks, Roger. Another type of legal obligation are employment tax records. This would include employer identification numbers, amounts and dates of wages, annuity or pension payments, information about annuity or pension payments, tax payments, personal identification information about employees, tip allocations, which, by the way, is very important if you are in the restaurant or food industry, inclusive dates of employment and job titles. All of that information needs to be saved in a form that, as Roger indicated, can be provided to taxing authorities. Business asset records. Companies need to retain proof of ownership and or sale. Companies need to be required to show amortization, depreciation, gains, losses, or deductions, as I referenced earlier. And companies must keep original copies of deeds and proof of payment. With respect to business ledgers and other important documents such as journal entries, profit and loss statements, and financial documents, again, these are documents that must be maintained and preserved. With respect to legal documents, that includes bylaws, board of directors minutes, annual meeting minutes, business formation documents, etc. Those documents must also be preserved. Bank account records, credit card records, and human resources files must also all be maintained and saved by a company. Roger referenced the statute of limitations periods, which of course do govern how long you need to keep documents in any form. I would suggest to you that with respect to the legal documents, bank account records, credit card records, human resource files, business ledger, and other important documents, and business asset records, that you should keep those documents for a minimum of 10 years. And I say this because you cannot anticipate when litigation could come in the future. And if you got rid of documents, you're not going to be able to defend yourself. So these documents should be maintained for a very long time.
You know, Lisa, let me jump in. I'll go one further on legal documents. Every corporation should have a minute book, and which has the articles of incorporation or certificate of incorporation, bylaws, board minutes, shareholder minutes. I think that ought to be kept indefinitely. I'm not sure there is a time when you can safely eliminate that, because you see companies that are around for 20, 30 years before they exit or get sold, and then those documents become important. And it's a lot easier if you have them than try to recreate them or scramble to get public records. Get them from public records, the ones that are available.
Okay, and Roger, and tax returns as well?
Well, tax returns, that's a little trickier. I know you're going to get into the specifics, but you keep the tax returns for as long as the statute of limitations period, and that's generally 3 years, 4 years for state returns in California. It's 6 years if you have a substantial understatement of tax, which is more than 25% of gross income. However, the reason I say it's tricky is because your tax return might be necessary to establish something like basis in property, or maybe you had a like-kind exchange. And that's an issue that there may never be a tax recognition transaction until maybe it's 20 years down the road. And then we have to go back and support whatever the basis was, and we may need those early tax returns. So even though, you know, everybody says, yeah, keep tax returns for statute of limitations 3 years or 6 years, I don't see a reason to get rid of those, because if there's basis information on it, you may need that way down the road. And the other thing, and I think you're probably going to get to this later, but it's so easy to keep electronic copies of things now. And that it's not like the old days where you had to fill up, you know, eventually have a warehouse full of paper, although we still do. You can keep electronic copies of a lot of this, and I'm sure part of your presentation will maybe include when you can start safely moving paper documents to electronic storage.
Thank you, Roger. Yes, it will do that. So getting to the guts of some of the, just to recap some of what Roger said and add a little bit more detail. So the question is, what is the duration for which I need to, or a company needs to retain documents pursuant to tax laws and regulations? As Roger indicated, it depends on the period of limitations during which you may seek a refund or the taxing authority may conduct an audit. You need all of the documents regarding your tax returns if you want to amend your return or if a taxing authority elects to audit your return. With respect to business income records, generally you need to maintain or keep copies of those documents for 3 years if you owe additional taxes, unless, and these are the exceptions, you don't report income and the underreporting is equal to or greater than 25% of your gross income as shown on tax returns. And in that situation, you need the records, business income records, for 6 years. If you don't file a return or you file a fraudulent return, there's no limit for how long you need to maintain those records. If you intend to claim a credit or refund, you have to maintain those records for 3 years after the taxes are paid. If you intend to file a claim for loss of a worthless security, you need to maintain those documents for 7 years. With respect to employment records, for tax purposes, these records must be kept for 4 years after the date the taxes were paid or due, whichever is later. With respect to business asset records, the statute of limitations begins to run from the date of the sale. You know, this would be another set of documents that I would suggest you want to maintain for a longer period of time than other types of documents. With respect to legal documents, there is no limit on how long you need to save these documents pursuant to federal or state tax law. And I wholly endorse Roger's reference to save them indefinitely. With respect to bank account and credit card records, those need to be saved for 7 years. With respect to human resource files for applicants, the records need to be saved for 3 years. For employees, the records must be saved for 7 years from the date of termination or 10 years after workers' compensation benefits were paid. If there is litigation involving employment-related issues, records must be maintained from 5 years after the date of the conclusion of the litigation. The next slide touches on something which I referenced earlier. I just wanted to make sure this was flagged and everyone asks themselves this question. If I am in a cross-border or international type transaction, are there laws of other countries or jurisdictions which may require me to save documents for a longer period of time and or to have original copies of documents? There's a lot of variance country by country, and this would be a question you may want to pose to your counsel. And again, this is governed not just by laws and regulations of different jurisdictions, but also by cultural norms in different jurisdictions. With respect to this litigation issue that I referenced, this is a very important issue which should inform your decision in large part. The two main considerations that you need to think about are, one, when you need to save documents or use documents which you saved in order to mount a defense or pursue a claim. If you think you may need those documents, you better save them, because if you think you can rely upon getting them from an opposing party in a lawsuit, think twice. As someone who's been litigating a long time, I can tell you one of the toughest things that I have to deal with in a lawsuit is getting documents from my opposing counsel. So keep your own records. Don't rely on anyone to get them to you. That issue needs to be balanced by a completely contradictory different issue, which is, if I have too many documents retained and saved and my company gets sued, it's going to be really costly for me to produce all of those documents in the context of discovery in a lawsuit. I've been in a lot of situations where companies have had to spend hundreds of thousands of dollars going through documents, categorizing documents, analyzing documents, producing documents, combing through documents. And this was a result of the fact that the company had not created a proper document retention policy, which essentially called for the destruction of unnecessary documents on an annual or semi-annual basis. Most large companies have document retention policies which involve the destruction of unnecessary documents. So this is not an issue that a small company has to face. However, if you scale it down, a small company could spend a lot of money in defense and litigation if it has too many documents. So the decision needs to be carefully made on a case-by-case basis. Now, when you make this decision, there are certain things you got to think about under federal and state law. The first is this concept of litigation hold. Lawyers and litigants are obligated, once there is a whisper or a thought about potential litigation, to cease destruction of all potentially relevant documents. If you hear that a customer may sue your company or an employee may sue your company, you must take steps to preserve those documents. And this means making sure that they are safely stored in your cloud service, or they're not shredded in your shredder. A failure to comply with this obligation brings with it many penalties, all of which are really horrible. One of the main ones being that you can lose a lawsuit by simply destroying key documents. I'm sure you've all heard about this. It's been in many movies. Documents are buried or destroyed, and it is just not a good idea. The worst thing in the world one could do is to try and cover up some bad information. It's always the cover-up which gets the company, not necessarily the bad act. There are federal and state laws and regulations, in California in particular, which require that documents be produced in a digital format and which govern how that works. So when and if your company, hopefully never, but when and if your company gets into litigation, there will be a burden on your company to comply with these discovery rules concerning production of digital records. I just want to point that out because companies need to always remember that when they're producing documents in litigation, they're not just producing hard copy, but they're also documents, but they're also producing digital copies. Finally, I want to mention what's called the best evidence rule, which is really incredibly arcane. It's a rule of evidence in California which provides that you have to produce at time of trial the quote-unquote best evidence. That would be an original document. Two examples in my recent cases where this came up, both of which came up in trials. In a recent trial from last summer, my opposing party wanted to produce a document which had been issued by a business licensing agency in San Jose. And I objected on the best evidence grounds, and the opposing party had to run to the licensing agency over lunch and get a certified copy of that document. So, believe it or not, certified original documents with the actual stamp where the paper gets sort of crushed and a different color is put on top of the original is required. Another situation I had a few years ago, a business litigation matter, I was asked to produce an original deed, and the ground that was asserted by the opposing party was the best evidence rule. Fortunately, we were able to find it, but this came in the middle of trial. And again, even if lawyers have a tacit agreement amongst themselves not to enforce the best evidence rule at trial, lawyers sometimes change their mind for tactical reasons. So having access to important documents, hard copy, is oftentimes needed. Question, in what form should you preserve these documents? So this speaks to paper versus digital. Some documents have to be preserved in paper form. This includes the following documents: wills, codicils, and testamentary trusts, documents related to adoption, divorce, and other family law matters, court orders, notices, and other court documents. And by the way, on that category, you should be able to rely on your counsel to save those documents for you, and do confirm with your counsel that they have saved and are saving those documents. And this is why Roger, I think, Roger, maybe you can correct me, but one of the reasons why Roger said we still have a semi-warehouse full of documents, because we as lawyers are obligated to maintain your legal files. Right. Notices of cancellation or termination of utility services, notice of default, repossession, foreclosure, or eviction, product recall notices affecting health and safety, documents relating to the transportation of hazardous materials. Again, all of those documents need to be preserved in paper format. As you make these decisions about documents which were not just referenced, rely on your comfort zone. Everyone's got their own version of it. And this is to say the extent to which you want to rely on digital resources to preserve your documents is probably going to be based on the extent to which you do or do not trust technology. There is, what we all know, a technology meltdown from time to time. You have to take that into consideration and either do more due diligence on your cloud resource or have a backup server, whatever that means for you. You have to consider the issue of hacking and your legal obligations to maintain the privacy of certain documents, such as employment records and tax records, and ask yourself whether or not that's too big a risk for you to handle. I would imagine that there are, well, I know that there are plenty of resources that can deal with that issue, and I assume that all of you have checked those out, but hacking is a consideration. Your workforce population, you need to think about who works at my company and who is comfortable working on a digital basis and who really needs to touch paper. And you need to consider your service provider's requirements, what they require you to do. Question, for how long should you preserve these documents? I won't repeat myself, but just remember what I discussed with respect to the fact that you need to consider litigation issues. That's best evidence rules and compliance with statutes. And again, the legal requirements for the certain types of documents. Now, there's a long list of documents that can be preserved in electronic form, and I'll tell you some of those. Wire transfers and electronic checks, bank deposit images, tax returns, tax receipts, contracts, and I do want to point out on contracts, you may want to save a wet signature if you've got one, warranties, license agreements, SEC reports, Securities and Exchange, auto insurance, business operation documents, marketing materials and collateral, emails, text, tweets, video and photographs, voicemails, trademark registrations, and employee handbooks. Some other electronic versus paper issues that you want to think about. One is this question of electronic signatures. Is an electronic signature valid? Yes, it is. There is a 2000 statute which provides under federal law for electronic signatures, and it is heavily relied upon by companies and individuals, and electronic signatures are considered legally valid. Another tangential issue is some documents, in addition to being saved or not being saved, need to be notarized or recorded by a county recorder. Different issue, but it's related to how you deal with your information. This includes grant deeds, deeds of trust, mortgages, and leases. And on a separate but issue, which you're probably slightly curious about, and that is the question of what do you need to save in hard copy or digitally on a personal basis. And on a personal basis, so you as an individual, you need to save in hard copy the following: passport, driver's license, identification, documentation, workplace rules, business licenses, and health permits. And as in your capacity as an individual, you need to also save records which support your income. That's your W-2s or Form 1099s, bank statements and brokerage statements, documents which support your expense claims, sales slips, invoices, receipts, canceled checks or proof of payment with respect to your real estate, closing statements, purchase and sale invoices, proof of payment, insurance records, and Forms 2119 if you sold your home before 1998. And last, of course, documents relating to your investments. That would be brokerage statements, mutual fund statements, Forms 1099 and 2439. These do not all need to be saved in hard copy, of course. And as an individual, you're probably wondering, how long do the taxing authorities require me to save my documents? It's the same as for companies, and it's generally 3 years unless the exceptions I indicated before apply, and that's to say 6 years if you don't report your income or you underreport it. If you don't file a return or you file a fraudulent return, there's no limit on how long you need to save your documents. And if you intend to file a claim for loss of a worthless security, you need the documents going back 7 years. Finally, I want to speak to the issue of what is a document retention plan? What are the mechanics? There are lots of different types of plans. Some speak to duration of destruction of documents, as well as how documents should be maintained digitally and in paper format. Some speak to what paper documents need to be maintained or not maintained. It's all across the board, but the key here is to create a plan, to be conscious and mindful of creating an actual plan for your business and, of course, yourself, I suppose, and to comply with your plan and consistently comply with your plan. The last thing in the world you want to do is be in the middle of litigation and have to tell a judge or a jury that you only saved certain documents and not all documents, or vice versa. So whatever your plan is, follow it and look at it every so often to make sure that it's consistent with the changes in technology. Roger, do you have any comments or additional thoughts to add?
Well, yeah, first of all, in response to some of the questions we've gotten, These materials will be available. They'll be posted on SlideShare as well as on Royse University if you'd like to get access to the materials. And Lisa will be available for follow-up by email. But one thing I think it's worth pausing on is that the technology seems to be speeding ahead and making it really, really easy to save documents like never before. Not only documents, but also signatures. And I think a lot of companies have gone paperless, and a lot of us are. And it's not. I think the important thing to remember is that it's paperless and not paper-free to start with. As you'd mentioned, there's certain documents that you just have to have paper and ink. But more and more, we're seeing a lot more types of documents that can be saved in offsite storage. And I think you touched on some of the issues around that. But I think it's worth, again, pausing on just the regulatory issues when we start sending documents offsite or to places where security might be compromised. And Lisa, maybe you could talk a little bit to what are the sorts of documents that we'd have to be really concerned about, and what sort of additional security features would we want to put around those documents if we are sending them into electronic storage?
Roger, the types of documents that companies need to be especially concerned about possibly escaping into everyone else's inbox are documents which are private as to a company and private as to an individual. So with respect to the private as an individual, this would be anything related to the employer-employee relationship that a company has with its employees or its independent contractors or anyone that has provided any work for the company. Companies have an obligation under federal and state law to maintain the privacy of those documents. This includes not just the tax returns or tax information about your employees, but anything. We all know about HIPAA laws and regulations. They speak to, of course, medical information, and that area of law is very robust and protects individuals and employees. And again, that's another type of employee-related document where privacy is a key issue. And therefore, if you as a company have any documents related to your employees, HIPAA or otherwise, you need to be very mindful about preserving them. Roger asked the issue of how to do that. I think the key here is to, if this is in your comfort zone and you know a lot about this type of issue, go ahead and make these decisions. But if it's not, you need to find someone who knows this issue and hire that company or individual to do the due diligence that you need to do. And I say this because it's not going to be an excuse when confidential employee documents were leaked out. It's not going to be a good excuse to say my cloud service screwed up. That just isn't going to work because you have to own, you the company have to own this issue. With respect to company-related documents, I would say, in addition to employment-related documents, all documents related to any intellectual property a company has. So a company needs to be very careful about maintaining as confidential its trade secrets and its intellectual property. If a company fails to maintain as confidential its trade secrets, the trade secrets will no longer be confidential, and a competitor or an employee can steal those trade secrets and not be sued. So it's incumbent upon companies to take a very strict eye towards preserving as confidential and not allowing your cloud service to destroy that confidentiality, your intellectual property and trade secret information. Finally, I would suggest that all of the key information regarding the financial aspects of your company should be very carefully maintained off-site, as those documents, again, are highly confidential and can, certainly in the hands of a competitor, give an advantage to another entity.
So Lisa, is this something that would be an appropriate topic for business insurance?
That is a great question. I don't have an answer to that question. I'd have to ask a broker.
Okay. Okay.
But I would certainly think that if a company, well, I would certainly think that if a company that's your cloud company hosting your documents destroys the confidentiality, that you might want to get behind their insurance policy to indemnify your company if your company is sued by an employee for a breach of confidentiality. Whether or not the company can maintain its own insurance policy, I'd have to check with some brokers to find out.
So we have a couple of fairly technical questions here. Let me give it a try. And this is one is regarding safe cloud storage. And these are the sort of documents that you describe where we have an obligation, or the company has an obligation to protect private information, maybe subject to NDA, or maybe it's just because it's private. So the questioner asked to distinguish between storing them unencrypted when they're encrypted by the cloud storage provider, which holds the key to encrypted access, and they're encrypted by the firm prior to sending them to cloud storage, meaning that the cloud storage provider cannot access them. So I gather here the question is has to do with whether that limits the liability of the company, or one of these sort of formats is better than the other with respect to the company's liability.
I would say that the most, I would personally not like to be in a situation where a cloud company or whoever is hosting, saving your documents for you digitally, where they don't have the ability to release them to the outside universe. So whatever that means from a technology standpoint, that would be what I would want to go with.
Okay, we have a questioner asked you to comment on the value of digital signing of the original authenticity of sensitive documents that are stored digitally.
So I mentioned save wet signatures. Typically, what I do is I get wet signatures on really important documents, say settlement agreements and deal documents. And I suggest to you that if you can stomach it, please do try and save the wet signatures, because the last thing you're going to want is to have to explain to a judge who might be very conservative and not be open to a digital copy that the federal statute does not exonerate you from this obligation to have a wet signature. So you can sign it digitally, but you also may have an obligation to sign it as a wet signature.
Okay. All right, and again, if you have follow-up questions or you'd like to drill down in more detail on this, next slide, I'd invite you again to email Lisa at lchapman@royslaw.com. This webinar and the slides will be available on royceuniversity.com, as well as a video on YouTube and as a podcast on iTunes. In addition, another reminder, we have our next webinar coming up on May 1. It's on trade secret protection at 10 a.m. Information is on our website. And following that, the next thing we have scheduled is our AgTech conference, a full day-long conference in Palo Alto at the Oshman JCC on May 12th. So with that, unless there are any further comments from you, Lisa, or any further questions, I think we're going to go ahead and conclude the webinar. Thank you.